NACDL is the association of the nation's criminal defense bar.
So we wanted to start off a little bit with kind of an explanation of some of the technology that is being used, and then we'll move on to just how widespread that is and the lack of any sort of protocols in many locations. Hopefully, if all the technology holds up correctly, we will also be able to give a live demo of a UFED reader from Cellebrite extraction, and then we will close with some more of the legal challenges based upon all these really invasive things that are being used. Mobile device forensic tools it's a very growing industry. There's a lot of money involved here, but the main companies I would say are Cellebrite, Magnet, and Grayshift. And Grayshift has recently partnered with Magnet for Magnet to be its distribution. Now, Cellebrite is the one we probably see most often. That's probably the biggest player in the field, and then Magnet would be second, especially now that they have partnered with Grayshift for their tool called Graykey. But there are a ton of other companies out there. Oxygen is one, Parabin. There's many different companies that you're going to see, but I would say the vast majority you're probably seeing Cellebrite related extractions and tools. What is an extraction? So pre-smartphones, we probably saw a lot of computer hard drives, and you'd hear people say the image, right? It was an image of a drive, which was like a bit-by-bit copy, right? It was most commonly referred to. Well, the way smartphones are built, especially now, it's hard to generally get we would call a bit-by-bit copy. And so there's a lot of different types of extractions, which is the content of the data that's being pulled off the phone or the tablet or GPS. I've also recently saw drones, which is fascinating to see an extraction on a drone. Didn't think I'd get to see too many of my clients be able to afford one, but we did have a case. It was really interesting also having to litigate that with the FAA. So with that, though, depending on what kind of phone it is, what the operating system is, what the settings are, whether or not it's locked, if there's a passcode, if it's encrypted, all these things really affect just how much data can actually be pulled off the device. And it's so particular and specific that it's hard to tell you every single example. In fact, there are companies that have big data sheets about what different file extractions they support and for which phones, and sometimes they break it down even by, this phone, if it's with this carrier for Verizon or if it's for AT&T, you may be able to do different things on it. And so this could get really complicated very quickly. Obviously, that is way too much detail to go into today for this presentation, so we're not going to be that intricate. But just to say that there is a lot of information that's being contained on any of your devices, and that these tools are being actively updated all the time in order to get more and more of it and be able to use it in more useful ways mostly for law enforcement. Cellebrite's main products are UFED Touch 2, UFED 4PC, and Physical Analyzer. So you can actually see the picture in the top left corner there. That is a UFED Touch 2. That is literally a standalone tablet that would connect to the phone and be able to extract the data from the phone, oftentimes being automatically able to detect what phone it is being connected to. UFED 4PC works very similarly, but instead of a standalone device, it's actually a software on a desktop or a laptop that would be connected to the phone. And then Physical Analyzer is what analysts and examiners are using in order to actually review the data. Magnet's competing product, its main line of products is called Axiom. One of the bigger things about Axiom is that it also is used very commonly for hard drive images, both PC and Mac. So we've all seen through the news complaints from law enforcement about encrypted phones and not being able to get into phones. And while, yes, it's true, sometimes they have difficulty getting into phones, the amount and how often that is true has been greatly exaggerated. And so there are tools that are more advanced tools than what you're seeing on most cases, or what you can get if you're defense. And that's Celebrate Premium, Celebrate Advanced Services, and GrayKey. Originally, this started with Celebrate Advanced Services, then called Celebrate Advanced Investigative Services, where law enforcement would actually send the phone to Celebrate, and Celebrate would actively do a process that they consider a trade secret and proprietary, as we heard about earlier today, and the phone would be returned unlocked, or sometimes, depending on what your contract would be, they would actually do the extraction for you. And these were for phones that could not be unlocked or accessed without the passcode using the standard software, standard hardware that they have. Then came along Grayshift, and they produced a product called GrayKey. Now, GrayKey basically made it so that law enforcement had an in-house tool to be able to break into these phones, specifically at that time iPhones, but later they've now expanded to Androids. So seemingly needing to meet up to their competition, Celebrate started offering Celebrate Premium, which became an in-house on-site version of advanced services. GrayKey and Premium are law enforcement only tools that I've never been able to get access to, and if any of you do, please contact me. I'd love to talk to you. Advanced services, though, they've told me that in theory it's not open just to law enforcement, that it would be open to the defense, but they would want some sort of court order, something that shows to them that this is being authorized by a court, which, by the way, they do require from law enforcement too, either a court order or a search warrant. I have not had the opportunity or the need to do that yet, but I would love to talk to you if you do and see if we can make that happen for you if it's beneficial to your clients. This is just to say that this is a ongoing cat and mouse game between the phone companies and the digital forensic companies, the mobile device forensic tool companies. And it doesn't seem like there's going to be an end anytime soon. Every time they build a better security system, somebody finds a flaw in which to exploit it. But with that, I'm going to turn it over to Harlan.
Thanks, Jerome. Hey, everyone. My name's Harlan Yu. I'm the executive director of Upturn, which is a technology and justice nonprofit based in Washington, D.C. I'm going to be talking today about a research and advocacy report that my colleagues and I published in 2020 called Mass Extraction, which examines how law enforcement agencies from across the country have been using the kinds of forensic tools that Jerome just introduced. So just to start, a little bit of context based a little bit on what Jerome was just describing. Over the past few years, we've seen significant public attention on a number of high-profile cases involving potential evidence on mobile phones, especially in cases where law enforcement has claimed that it can't access the data on the phone due to encryption. So some of you may remember in 2016, there was a dispute between Apple and the FBI after the San Bernardino shooting, where the FBI tried to get Apple to help it get into the suspect's phone. Now, Apple refused, and after a protracted legal battle, the FBI announced that it had somehow gotten into the suspect's phone and didn't need Apple's help, perhaps based on some of these advanced services tools that Jerome just described. Later in 2019, similar issues were raised again after a shooting at the Naval Air Station in Pensacola, Florida. And just repeatedly over the years, the FBI and the DOJ have been seeking ways to more easily circumvent encryption and other security protections on mobile phones and other digital communications. And so at least from the FBI's framing and telling, law enforcement says that it's quote unquote going dark because of encryption. And therefore, because they can't get the evidence they need, again, what they call exceptional access or extraordinary access to these phones. And essentially what they're asking for is a key for the back door of all of our phones so they can get access to these phones. And, they claim too that, at least the way that they frame the issue, they're only going to use these tools in these kinds of high-profile cases, so-called terrorism cases or cases involving child exploitation. But our recent research in our mass extraction report, I think, paints a very different picture, especially at the state and local level, about how law enforcement is gathering a tremendous amount of information off people's phones off the street every day. So a few years ago, my colleagues and I at Upturn, including Logan Kepke, who's sitting back here. Logan, do you want to raise your hand? Who's the lead author of the report. He's going to be talking to you tomorrow about risk assessment, so I'll talk about this report. We started gathering as much data as we could about how law enforcement agencies across the country have been using these tools already today to gain access to data stored on people's cell phones, using, again, these kinds of devices. So in order to do this, we sent more than 110 public records requests to a range of major law enforcement agencies, police departments, sheriff's offices, district attorneys, and so on, and asked them to disclose through public records purchase records so we can understand what tools they have at their disposal. We asked them for records of use so we could understand how often these tools are being used by cops and in what kinds of cases. And we also asked them for policies that describe any guidelines or safeguards that they had in the use of these tools. We also poured through a number of government spending websites to try to create a comprehensive view, at least as far as what we could gather in the public sphere for how the government has been purchasing these tools, and also looking at vendor materials, materials from Cellebrite and Graykey in terms of how they market these tools to law enforcement and what they claim the capabilities are. And so here's what we found. One of our main findings is that every American is at risk of having their phone forensically searched by law enforcement. Our research documented more than 2,000 law enforcement agencies in the United States that have purchased a range of products and services from these vendors in all 50 states and the District of Columbia. These include each one of the 50 largest police departments across the country, and also every state law enforcement agency in all 50 states. So here's a map of all of the 2,000 agencies that we documented. And so you can see these dots scattered all across the country. And I should also add that this is almost certainly an undercount of the agencies across the country that already have these tools, right? These are just the ones that we could publicly document. And surely there are many more that we could not find documentation for and have obtained these tools in secret. One thing that surprised us during the research was that these tools were available and have been purchased by some pretty small departments, right? Shaker Heights Police Department in Ohio, Walla Walla Police Department in Washington, Lompoc Police Department in California, right? These are departments with maybe a dozen or a few dozen officers with pretty small budgets. And I think that just underscores how relatively cheap these tools have become and how easily available and accessible these tools are to law enforcement across the country. I should also point out, too, that we also saw evidence of a lot of inter-agency sharing of these tools. So you might imagine a larger police department purchasing these tools and then sharing that tool with other smaller police departments that couldn't afford it in the area. The FBI at the federal level also has a program called RCFLs, which stands for Regional Computer Forensics Laboratories. And they have 17 locations across the country, including right here in Chicago. And what these RCFLs basically are forensic kiosks that have the tools, at those kiosks where a law enforcement agency who otherwise doesn't have access to these tools could drive to these kiosks, bring the phones with them, and perform the extraction. So I hope it's pretty clear now that these tools are pretty widely available already and are currently in use. And I'm sure many of you all have probably seen these kinds of activities already in your cases. But maybe let's just talk at a broad picture in terms of how these tools are being used by agencies across the country. So another key finding of our research is that MDFTs are a pervasive tool for even the most common offenses. they're being used not only in the high-profile cases that the FBI and the DOJ like to talk about, but also in cases of graffiti, shoplifting, marijuana possession, prostitution, vandalism, right? You can read the list. Of course, also a full gamut of drug-related offenses. And our research shows that law enforcement has been using and performing hundreds of thousands of extractions since 2015, which is more than previously documented. So what we were able to glean a lot of this information from the records of use that we received from a variety of departments. And here are a few examples of the logs that we got. As you can see, there's a lot of variation in the ways that different police agencies keep these logs. Some will record the crime type or the offense type in the case that the cell phone was seized and extracted for. Others will list the specific model of the phone, and yet others might list and keep track of the legal authority used and the warrant number used when searching the phone. It might not surprise you that some departments don't even maintain logs like this at all, right? Many said, we can't even tell you how many phones we search every year because we just don't keep that information. And so there's no standard for doing this kind of public logging and tracking. But looking at the big picture of all of the records that we received through our FOIA project, we were able to basically sketch out a high-level story, which is that many law enforcement agencies are using mobile device forensic tools as an all-purpose investigative tool for an astonishingly broad array of offenses, and their use is just growing over time. You'll notice too, for example, and I just highlighted on the bottom right, that many officers aren't actually getting search warrants to do these searches. Obviously, in 2014, there was a Supreme Court case called Riley v. California, which made it clear that officers needed to get warrants for these tools. But what we found in our research was that in some departments, in a very large fraction of their searches, officers were relying on exceptions to the Fourth Amendment warrant requirement, in particular using consent searches as a way of not having to get warrants. For example, we saw in Harris County, the sheriff's office in Texas disclosed to us that between 2015 and 2019, more than half of the searches that they did of cell phones were based on consent. Similarly, about half of searches by the Denver Police Department in 2018 and 2019 were based on consent. And we saw similarly in Seattle about 30%. And of course, when a law enforcement officer relies on consent rather than getting a warrant, these searchers are then not subject to the constraints and oversight that warrants provide. Not to say that warrants oftentimes provide a lot of protection. It's a speed bump, especially when we see language in these warrants that are really broad, right, overbroad, where they say, give me any and all information on the phone, which we'll discuss later on this panel. But suffice it to say that consent searches and other exceptions to the Fourth Amendment are posing a major problem as well. So let's talk too about constraints, or really the lack thereof. As I said earlier, we asked departments for any policies that are in place, and many departments responded to say that they had no written policies to guide the use of these tools or training materials. For those who did, only a small handful provided us guidance that was actually specific to mobile phone searches. Many of the policies that we received were just general search and seizure guidance or broad guidance about the existence of the Riley Supreme Court case, and very little in the way of specific policies that limited the scope of the searches that were done, had something specific about data retention and retaining only the data that was pertinent to the objective of the warrant, or about data deletion or anything like that. And so what's the overall upshot here? Overall, we're seeing the growing use of MDFTs as a dangerous expansion of law enforcement's investigatory powers. And again, just to underscore how invasive these tools are, right? When a law enforcement officer plugs someone's cell phone into one of these tools, law enforcement can download all of that person's emails, contact information, text messages, location history, right? Because we have GPS and all sorts of location data on our phone. Mobile browsing history, right? Everything that I search into Google on my phone. Data from all my apps. And even in some cases, using the credentials. So if I'm logged in to Gmail or Facebook or other social media, using the credentials on my phone to then go get information in the cloud through my phone. And so this is what one commentator, because of how invasive these searches are and how much data is stored on modern cell phones today, a window into the soul. And of course, this also matters not just to the owner of the phone, but for all of the friends and family that they've been in contact with, right? The pictures of other folks, all the other text messages from the people that the owner of the phone corresponds with. So at a systemic level, right, and given how routine these searches already are, and given what we know about the racist and violent practices of law enforcement in this country, it's certainly more than likely that these technologies are being used disproportionately on our communities of color. And ultimately, we don't think that these tools ought to be used. Our report goes into a few more specific recommendations, which I'll briefly go over. The first is that we want to see a ban in the use of consent searches on mobile devices, and really for consent searches overall, even beyond mobile devices. As I'm sure many of you well know, consent searches are basically a legal fiction, right? There's inherent coercion in any search when a law enforcement officer asks somebody for consent for a search, whether that's a cell phone or a car or any other situation. Another recommendation was to abolish the plain view exception for digital searches. So for physical searches, officers can rely on plain view, which allows law enforcement to search and seize evidence in plain view of any place that they're lawfully permitted to be, as long as the incriminating character of that evidence is apparent. But for digital searches, it's kind of incoherent, right? It might have made sense in the physical context. You have a box and you're looking for a particular item and it's of a certain size. But when you're thinking about a file system on the phone, basically the exception doesn't really translate, and it's kind of incoherent in the digital context. But law enforcement officers are relying on the plain view exception to perform extractions that are and searches that are extremely broad. We also recommend that law enforcement maintain audit logs for every search that they do. And so the way to think about this is, imagine if you had basically a screen capture, a video of the investigator using the software that Jerome describes as they're going through the phone, seeing what appears on the screen to the officer in terms of the information that they're seeing from the phone, right? If we had an audit log of all the things that an investigator saw, we think it'd be easier for defense lawyers and judges and others to essentially play back the series of steps that an investigator took. That way, it'd be hopefully easier to challenge or have a better chance of challenging overbroad searches and suppressing overseas information. Another recommendation, which is pretty straightforward, is that law enforcement agencies delete any extracted cell phone data that's not relevant to the objective of the warrant, and also to seal any extracted information at the conclusion of the case, right? The idea here, and what we've seen in some cases, is information from somebody's cell phone being extracted and used in one case, then being used again months or years later in an unrelated case, or being used in more general purpose investigative databases like gang databases. And then finally, the last recommendation we had was that law enforcement agencies should be required to publicly log the usage of MTFTs, essentially those logs that you saw on the screen earlier, right? It's not a standard practice. There's no requirement to do so, but we believe by requiring law enforcement agencies to do that, it will prompt better policy and advocacy in response. So I'll stop there for now. The report is online on our website, upturn.org, and also it's in your CLE materials, and happy to talk about any of our findings. So I'll pass things over back to Jerome, who will give a live demo, and then we're going to go to Aisha.
So right before we do the live demo, I just wanted to show this little chart here. Ideally, you want a copy of the extraction to be turned over in discovery. That's what your expert's going to need to look at. That's what they're going to want to be able to make their own reports off of. However, as I know, not everybody can afford an expert all the time, or sometimes you also want to be able to review things on your own while you're prepping for trial or for a hearing. So in those situations, at minimum, you're going to want the UFID reader report for Celebrate and for Magnus, the portable case file. I'm going to show you a live demo to show you why a UFED reader report is so much better than a PDF. Just to give you an idea, the demo extraction we're using was from my unit just kind of passing around amongst each other for about a month, not even using it as our real phones, just kind of intentionally putting test data on it. And if you were given a PDF of that, it'd be over 2,000 pages, which could be very frustrating and difficult to look through. And frankly, if somebody was to ever hand me a printout copy of 2,000 pages of a phone extraction, I don't know what I would do to them, but probably shouldn't say it on tape. So with that, hopefully this live demo will work. So the first thing I wanted to show was you can actually see that the data is already broken down to categories for you. This is being automatic, right? It's analyzing the data and categorizing it. It's not 100% perfect, as unsurprisingly we've discussed, no algorithm is, but it is pretty good, and it does save you a lot of time initially. One of the benefits of having in this format, though, versus a PDF, is that you can open things like browser tabs and be able to flip back and forth between them without losing your place in where you originally were. So for example, if I wanted to filter this to only show, actually, let me take a step back. As you can see the photos here, it says that 14,593 images that were extracted off this device. That is a lot to go through. Let's say I'm only really interested in the ones that have location data, right? So I could filter it to metadata location, and I'm now down to 31, right? Now, a PDF, you can't really do that. You can't filter in the same way. Now, let's say I wanted to look at the contacts for a minute. Take a quick look at that, and I come back, and it's just as I left it, right? There's no bouncing back and forth. There's no Control F, right, to find. There's no trying to write down the page numbers and any of that. So this makes your life a lot easier. All these different categories have some level of filtering depending on what the category is. So I'm not going to open messages just because it will reveal a bunch of people's phone numbers, but the messages would allow you to limit by sender, by receiver, by messaging app, also whether or not it had been deleted data. And so just talk about that real quick. See the white numbers next to each category are the numbers of pieces of data that were extracted from the phone that fit in that category. So for example, we have contacts here. That white number is 119. There were 119 contacts that were pulled off this phone. The red number is the number of ones that have been deleted and were recovered. So 4 of those 119 had been deleted but were recovered. To be clear, that doesn't mean that there weren't other things that were deleted, they just may not be recoverable. I will say this is becoming less and less common to be able to pull deleted information. It's kind of being relegated now to a lot of the cheaper burner phones, which we still see clients use, but it's slowly being faded out based on security upgrades, both for iPhones and for Androids. And we rarely see much else in smartphone land. Another thing that is great is that you can search across all of the data, right? And so it'll give you results that are very similar to Google results, right? And it'll give you a long list, and you can click on it. And so say I had a case where the co-defendant was named Ben. I want to see all the mentions of the co-defendant in the case, or maybe there's the complainant. I want to see all the mentions of the complainant on my client's phone. I could do a keyword type, and search across all the data and get these results just like you would get in a search engine result list. Additionally, you can do more advanced searches if you would like to, including making sure you have all the terms of a particular thing or want without certain terms. And then within each filter category, you can also do a search just for that category, if you're only looking for certain things related to that information. Another important part of this, too, is you can also keep track of your work. One, you could save your work as a file and reload it later. You could also tag, right? So if this picture was particularly important to me, right, because let's say it shows the camera make and model that took this photo, and that camera make and model is the same model of this phone, which doesn't definitively mean it was taken by this phone, but it's a good indication that it may have been. And it has GPS coordinates that may be relevant to my case. In this particular situation, this was a photo taken in the subway of the Church and Chambers Street stop in New York City. So let's say I find that important in my case. I could tag it. I could also create other tags, but these are the ones that come standard stock, right? And so I can now tag that. Oops, it's not showing up correctly here. The screen's not working. So normally, you could tag that. And then you would be able to later go to the tagged section and look at all the different things that you tagged, right? And so you don't have to go back through and look at everything all over again when you found the things you were looking for. There's also the timeline feature, which puts everything, as the name suggests, in chronological order, right? So you can actually walk through what somebody was doing throughout a particular day or week, for that matter, if you wanted to go that long. And then the last thing I wanted to show quickly is generating a report. So again, to be clear, this is a report in itself. A lot of people think when they get this UFED reader report, then they can open it, that it's the actual extraction. It is not. Why that's important, though, is that when you're making these reports, or when an analyst makes these reports, they can actually choose what from the extraction to include. And so if you're not getting the actual extraction, you're just getting a UFED reader report, you may be missing information, and they may not have included something. Now, sometimes this could be malicious, or sometimes it's just that prosecutors, as we know, often think, oh, this is not relevant, I don't have to turn this over, when that's actually the key to my case that you left out of the report. So you can see you could do it, it could be by date, it could be by category, all these different possibilities. The other side of this is, for your benefit, you rarely want to put in the entire extraction or the entire report into evidence, right? And so you could also be able to limit to what you want to put in to admit, right? So you can also limit that for the purposes of making trial or hearing exhibits. And last thing I wanted to show, just going back for a second, when this is what their screen will look like in their physical analyzer, it's very similar looking. You could see how easy it is for them just to, literally all you have to do is click that to get you a UFED reader report that works like this. And so when they say to you, oh, all we have is a PDF report, or all we have is an Excel workbook, it's literally because they chose not to click a checkbox. And so there's really no excuse for that at all. And so you could see just how useful this is. I mean, you could do an entire class on all the different filters and all the different features that it has, but I think you get the idea from this now. And with that, I'm going to turn it over to our colleague.
Awesome. Hello, my name is Aisha Dennis, and I'm a staff attorney for the Fourth Amendment Center for NACDL. And the Fourth Amendment Center provides pro bono legal assistance to attorneys who are litigating issues at the intersection of the Fourth Amendment and technology. And you don't have to be a member of NACDL to take advantage of that resource. Obviously, we'd love for you all to be members of NACDL. But either way, if you do have a case that involves a cell phone search, which is what I'm going to talk about today, or some other case that involves technology and the Fourth Amendment, we are a resource to you, so please look us up. So in talking about challenging cell phone searches of warrants, or warrants of cell phones for cell phone searches, the number one case that you all should be aware of is Riley v. California. And I'm not sure if you've had a chance to read it. If you haven't, I would highly recommend it. It's really beautiful prose written by Chief Justice Roberts. And the simple holding of that case, which for the record was virtually a unanimous opinion, is that a warrant is required to search a cell phone incident to arrest. So unlike other items that are secured incident to arrest, like a purse or a book bag that can be searched, the court unanimously held that a warrant is required when a cell phone is obtained incident to an arrest. And in reaching that conclusion, the court conducted a really vivid privacy analysis. And in that privacy analysis, they balanced the governmental interest in those searches with, which is the traditional way to do it, with the individual's right to privacy. And what the court held is that privacy wins when you're doing that balance, because cell phones are quantitatively and qualitatively different from other items that have been subject to search. And so quantitatively, as my other panelists have mentioned, cell phones really do contain just so many different distinct types of information. If you look in a wallet, you may be able to find photos or credit cards. If you look in a cell phone, you're going to find emails and text messages and photos and browsing history and location and call logs and you name it. I mean, there's so much in our cell phones. And within those distinct types of information, there's just a huge storage capacity. So if you look at photos, which Jerome just had in his UFDR report, there are 14,000 photos. You can't carry around 14,000 photos in your wallet. And those photos are going to date back really far. And so, again, the court is really focusing on how quantitatively cell phones are different. The court also focused on qualitatively cell phones being different because the types of things we keep in our cell phones, the types of things we may search late at night on our Google app in our phone, is going to reveal things that are really highly personal in a way that perhaps a wallet or a book bag wouldn't. And looking at that interest, the government interest on the one hand, the court says, well, sure, for officer safety purposes, maybe the government should be able to search cell phones. For evidence preservation purposes, maybe the government should be able to search cell phones, but what about the individual's right to privacy? And on that side, the court, again, with this beautiful prose, talks about how the proverbial visitor from Mars might conclude that cell phones were an important part of our human anatomy. I see a lot of us right now have our cell phones on us. I have my cell phone right here because we carry them around. I mean, they're like our anatomy. And the court also pointed out that a cell phone search would typically expose to the government far more than the most exhaustive search of a house. And the house being the part of our society that has typically and historically had the most privacy protections. Now you see the court hinting or perhaps just explicitly stating that cell phones should be entitled to at least as much protection, if not more. And so in conducting that balance, the court says privacy clearly wins and a warrant is required. And I take time to go through that because I do think the government will often, or the state will often say, the simple holding of Riley is just you need a warrant, the officer's got a warrant here. But what we as the defense practitioners have to do is really point out the underpinning reasoning for that conclusion, which really is that privacy interest that the court is recognizing. So how do we take Riley and apply it to device search cases, which in many instances you're going to have a warrant? And the way that a lot of the opinions that deal with this issue are written, and a lot of the ways that practitioners have argued it, is to start with the text of the Fourth Amendment. And so, the right of the people to be secure in their person shall not be violated, and no warrant shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. And that is, the probable cause in particular requirement right in our Constitution. So just because they got a warrant doesn't mean the warrant is sufficient. We go back to the Fourth Amendment to figure that out. And so first we start with probable cause. And the definition of probable cause is a fair probability that contraband or evidence of a crime will be found in a particular place. So just reminding the court, because sometimes I think people, water down probable cause to say, is there a reason to believe there's going to be evidence? And it's not a reason. Is there fair probability, which I think is a little higher of a standard. And so that's one question when you're looking at these warrants. Did they meet the probable cause standard? Then there's also the particularity standard, and I'll just put a few different definitions of particularity here. But the basic idea is there a specific enough description where the officers know where they should be searching so that they're not just doing a general exploratory fishing expedition into a phone or rummaging through all parts of the phone without any clear guidance. And then there's the concept of overbreadth that kind of puts both, I think, probable cause and the particularity requirements together, which basically says, in the warrant, is there a description of the items to be seized that is not broader than what is justified by probable cause? So, for instance, maybe officers have made a showing that within a phone they should be looking at photos because there's probable cause to believe that there's a particular photo in this phone, but they have probable cause for that. Did the court also allow them to look at the entire phone? Because if they're able to look at, text messages and call logs and locations, then that's going to be a broader ability for them to search than what was justified by the probable cause. So we would call that that the warrant would be overbroad. And so how does this work in a particular cell phone case? Because, again, what you're going to have is an officer who has the logic that, criminals keep evidence of crime in their phone, just the same way that lawyers keep evidence of lawyering in their phone, and teachers keep evidence of teaching in their phone, and parents keep evidence of parenting in their phone. Criminals are going to have evidence, and I think, there's certainly an appeal to that. So what do you do about that? And then also, they're going to say that they want to search the entirety of the phone. We don't want to be limited. We want to look through the entirety of the phone. And so I want to take you through a case example from a case that I litigated, United States v. Oglesby, which is out of the Southern District of Texas federal court. And in that case, my client was arrested for a car burglary, which is a misdemeanor, and evading arrest. And at the time of his arrest, a cell phone was recovered. And pursuant to Riley, the officers got a warrant to search the phone. They did a thorough fishing expedition into that phone, and they found evidence of firearm possession and straw purchasing and firearm dealing, just a whole lot of pictures and other evidence of firearms. And so they charged him with 922G, which is felon in possession, in the federal court. And this is what the warrant affidavit looked like, which is hard to see, so I transcribed it here. And basically, the officer said that, for this crime, which I don't even think he specified, but he was referring to, when he said aforementioned offense, he's referring to this burglary of a vehicle. He needs to search the entirety of the phone. So photographs and videos and contact information and email addresses and, all of these different things, including things that didn't make sense, like CD-ROMs and CDs and DVDs that really don't connect to a phone at all. So clearly he was using some form of a template. But this is the kind of type of broad warrant that I think is typical. And certainly, this is a warrant that I faced. It's kind of hard to see here, but the judge gave them exactly what they asked for, down to you can search CD-ROMs and DVDs. So clearly these people aren't, in some instances, these judges are rubber stamping these warrants and aren't really thinking about how broad they are allowing officers to search. And so, what do you do when you get a warrant like that? That's super broad, that's basically based on the concept of criminals keep evidence of crimes in their phones, we should be able to look. And so overall, I would recommend that you try to argue the entire warrant is invalid. But given that now you've seen what a UFDR file is, you know how you can look through the evidence in the UFDR file and try to find what the incriminating evidence is. If in your case the incriminating evidence is in a particular part of the phone, then maybe you can also have a more specific fallback argument that, hey, judge, even if I can give you the fact that maybe officers are reasonable to look at location information or to look at call logs from this time to this time, they shouldn't have been able to look at other parts of the phone or other categories of information, or they shouldn't have been able to look outside of this particular time span. And so, again, what you want to do is be able to identify, okay, what is this incriminating evidence you do want suppressed, because that'll help you with some of these arguments. So, is it, again, located in images or text? And what is the date? Because, in my case, there was a burglary of a vehicle, or actually a few that happened over a month span, but this evidence of this straw purchasing and firearm dealing was dated like years prior. And so, the argument could be, in that case, sure, maybe it was reasonable. Obviously, you start saying it wasn't reasonable. But to the extent, Judge, you even agree with the prosecutor that it was reasonable to look for information in this month span across the phone, the officer certainly shouldn't have been able to look for years worth of data prior to the offense being investigated. And so what you're arguing in general with these warrants is that there wasn't probable cause. In this case, I'm arguing, the officer's using boilerplate language, including asking for information for CDs and DVDs, that the officer is using generalizations with no limiting principles. So again, this idea that criminals keep evidence of crime in their phones, that would apply to all criminals, all people suspected of crime. So there's really no limiting principle there. And then there's no facts that connect this particular phone to the offense. So in my case, it was literally he, was just arrested, a phone was on him, and that was it. That, you argue to the court, it'd be different if maybe there was evidence that he was on the phone with someone else or someone had said that he texted them about the offense or something like that. But just the fact that the phone was found on him incident to that arrest is not a fact that's connecting the phone to the offense. And then as far as particularity, you argue to the court that there's no date restriction here, as I mentioned before, or there's no content category restriction, that, again, maybe they could look in one particular part of the phone, but not all parts. And then you have to come back to Riley. I think, again, Riley is really golden here, reminding the court that the Supreme Court sees cell phones as part of our human anatomy, that the cell phones contain the privacies of life, and that in general, the Riley decision implies that probable cause for an arrest does not equate to probable cause to search a phone. So it can't be the case that just because we believe, or there's reason to believe that a person committed a crime, that automatically translates into probable cause to search their phone. And then, of course, unfortunately, in warrant cases, you have the hurdle of good faith. And so there are 4 exceptions to good faith. And I'm sure you all are probably familiar with them, but what you argue in almost all cases is that, one, no reasonable officer would have thought that an affidavit which says criminals possess evidence of crime in their phone was sufficient to establish probable cause, and also that the 4th exception to good faith, that no reasonable officer would have thought that even if there was some probable cause, that they should be able to search the entirety of a phone, that they would have recognized that they needed to be more particular. And so those are the arguments that I made in the Oglesby case. Luckily, we got a court who was open-minded and listened to those arguments and came out in our favor. And one quote from that decision that I like is this idea that search warrants require something else entirely than arrest warrants, that you have to have facts in an affidavit that establish a nexus between the things searched and the evidence sought. And then the court says, because if the Supreme Court decision in Riley is going to mean anything, courts cannot allow post-arrest search warrants to become arrest warrants by another name. And I really do just love that, because I think what the government wants to do, what the state wants to do, is water down this warrant requirement in these cell phone cases to allow cell phone searches for anyone. And I think the fact that, again, the Supreme Court has recognized such a vast privacy interest in cell phones, and the fact that they are requiring a warrant, they want to have a hurdle. So it can't be that any arrestee automatically gets their phone searched. There has to be something more required, and I think that's what this court is saying here. And so there are also other courts that have ruled in favor of defendants in these types of cases, including not granting good faith. And this is a list of the ones that I have been able to compile. So I'd recommend that you all check these cases out. And at this time, I think we are ready to take some questions, if you have any. There's a question. Sure. So the question was, often in these affidavits, the officers are going to be relying on their training and experience as the basis to search items in the phone. Have we come across that issue? And certainly, yes. Actually, in a case I recently litigated, in a different case in the Southern District of Texas, the Opoku case, I think it showed up in the opinion, but certainly in the oral argument on that motion, we discussed how the officer was relying in that affidavit on training and experience, but he actually didn't even write in what his training and experience was. So officers are trained to say, I've been a police officer for this long and I've done XYZ for, I went to this training academy, whatever. He didn't even do that. He literally just wrote training and experience, and the court found that to be a big problem. But even if they do follow their training and put in the affidavits what their training and experience is, our argument is that that's just not sufficient. That training and experience alone, and there certainly are cases that suggest that training and experience alone is not sufficient to establish probable cause. Certainly, it is an important factor that courts can consider, but not in the absence of some type of fact. And in this context, a fact that would connect the cell phone to the offense being investigated. Yes, so that case is up here now. It's the second case on the list, the Opoku case, and all of these cases are successes. So, I do think this is an area that is continuing to grow. All these are federal cases. I'm not as familiar with state court cases, but from the little bit of intel I do have, I do think this is a ripe area for challenge. These police officers really are hungry to get into these phones and are often writing affidavits that are wholly deficient. And so I would encourage all of you all to challenge these, because I do think courts are open-minded on this issue. There's a question here.
What was the live demonstration of, and how do we get into our possession that which you were filtering so many good things?
Sure.
How'd you end up there?
Yeah, so the question was, what was the live demonstration of, and how do you get it into your possession? Correct. So the live demonstration was of a Celebrate UFED reader report. And so that is a report that an analyst makes from the extraction of the phone. That should be turned over as part of discovery. The program comes with it to open the actual report. It's a free program called Celebrate Reader. If for some reason they refuse to turn that over to you, Celebrate actually will send it to you. I'd be happy to send you a copy. It's meant to be given out for the purposes of discovery, so people can open these reports even if they don't have the very expensive Celebrate license, which you need to open the actual extraction. And so it gives you as close as you can get to what an analyst opening the extraction can see without giving you the extraction, which requires an expensive license and training.
Hi, I have a question also about that live demo that we had. I noticed that in that demonstration, you had pointed out some of the writing or some of the stuff that was in red, showing that files had been deleted. I think it was contacts that had been deleted. I was wondering, in those extractions, what other items will it show have been deleted? For example, a lot of times people these days don't even make phone calls. They use Messenger or other kind of apps for, communication among each other. And let's say somebody deletes something off, a Facebook message or something. Should that ordinarily show up in one of these extraction reports that, some messages on Facebook, for example, have been deleted?
So I always hate to give this answer, but it's typical in digital forensics. It depends. I would say it's less common now. So a couple things. One, even if the data may be able to be pulled from the device, there are a lot of factors that go into why you may be able to get a particular deleted item versus another. So just because it's been deleted, and like say if you knew for a fact it was there and it was deleted, does not necessarily mean that you'll actually be able to recover it, even if it would otherwise be recoverable. Particularly when you start talking about Facebook and we call third-party apps, or particularly ones that are where most of the stuff is actually not being stored on the phone itself, right? So Facebook Messenger, the vast majority of Facebook app, the Messenger, Instagram, all that are actually being stored on the cloud, right? So the server. And so there's a lot of stuff that may be in that cloud that is not actually on the phone, or is only stored on the phone for a very temporary period of time. And just as we saw a shift from laptops and desktops to cell phones and tablets, we're now seeing a shift from that data being kept in the cloud and less on the devices themselves. And that's true with a lot of those apps.
Yeah, and also just briefly add too that, this is one of the ways that a lot of these vendors compete, right? Like in addition to getting into the phone and getting the extraction, these vendors actually have to go through engineering effort to essentially reverse engineer these apps so they can easily display them in formats that are easily understandable. So if you go through like the vendor materials, there's like every month there might be, for example, like the Celebrate update from April 2022 or May 2022, and every month they'll list like the new third-party apps and the new versions, because every time, like, let's say Facebook updates its app, it might make changes such that Celebrite also has to catch up to be able to present all the information that's there. Right. And so they're always going through this effort to support more apps and support the latest version of each of these apps.
Which, word of caution, if they've already done a search on your client's phone, try to get the phone back still, because later on there may be more data they can pull off when the technology gets better, and they may try to redo it, and you may end up with a lot worse than you had. So try to get it back if you can.
We'll take one last question.
Is there a way to, in my experience, they just say they want the phone. Is there a way to limit it to a certain time period or dates, or is it just the life of the phone?
So that depends on the device. Some devices, yes, you can limit certain categories of data being pulled off the phone or certain date ranges. Again, it's becoming a little bit trickier as time goes on, and the phone companies have been increasing their security. But even if they have to pull off everything, let's say just technologically it's not possible otherwise, they don't have to look at everything, right? And they could create a report just like that, then limiting, right, what categories of data or what date range. So there's no reason why they have to necessarily look at everything, even if the technology required them to take everything off the device.
So when I've been litigating this, my understanding would be that the officers are going to just seize the entire device, make a copy of the entire device. But our argument would be they shouldn't, as he's saying, they shouldn't have searched outside of a particular time limit, because they do have the ability to limit what they're looking at once they have it in this kind of Celebrite reader.
Right. So the question was, the officers are trained so you can ask them. They should know how to not inadvertently look at certain things that they weren't allowed to under the warrant. Correct? Yeah. So the answer is hopefully, because if not, then they're actually probably not qualified to be testifying about it. They're not actual experts. We've run out of time, but I'm happy to talk to anybody separately about this. But there's a big difference between somebody who can read instructions and press buttons and somebody who actually is an expert and knows why they press the buttons. Thank you, everyone.